Let me tell you a little bit about why it's wrong legally, because I think the legal case can often get very complicated, and it's important to see how strong the legal case is against it. First of all, it's an unprecedented decision to require religious institutions and individuals to pay for something that they regard as contrary to their religious beliefs. That's Professor Michael McConnell, who is one of the leading religious liberty scholars in the country, not a Catholic, but who really sees this as an unprecedented attack on religious liberty. It's also obviously a political and cultural problem, and it's a problem because it fails to recognize the contribution to the common good that Catholic institutions make. But legally, the case against it is very strong. First of all, free exercise. As you may know, under the case of Employment Division v. Smith, free exercise doctrine today holds that a generally applicable law will not be held unconstitutional if it is generally applicable and if it is neutral. Now, there's a good case here that this isn't a neutral law, but I won't really get into that because I think the case that it's not generally applicable is very strong. And that case rests on the fact that there's a really large exemption scheme within the Affordable Care Act. In other words, the Act doesn't exempt Catholics. It doesn't exempt those who object for religious reasons to providing abortifacients and sterilization and contraception. But it does exempt millions of people because their plans are grandfathered. It does exempt the Amish from doing this because they had objection to providing insurance. It has a scheme of exemptions, but it doesn't exempt this one particular group, people who have this particular religious objection to these goods and services. And so for that case, it's not generally applicable, and I think that that gives it a strong argument that it violates the free exercise clause of the U.S. Constitution. Much stronger case, though, is under the Religious Freedom Restoration Act, and I think that's a clear winner. And here's what that is. The Religious Freedom Restoration Act, in the wake of Smith, said that we should revert to a more robust conception of religious liberty, like the one that we had been governed by for many, many years. And that doctrine says that a substantial burden on religion will be struck down unless government uses the least restrictive means to achieve a compelling government interest. Now, I think that applies, by the way, to federal law. I think that we can all see that there's a substantial burden. As Professor McConnell said, and I noted earlier, right, for the first time, religious believers are being obligated to provide goods and services that they object to against their most deeply held religious beliefs. It's a substantial burden on this. Now, the accommodation is supposed to get past that substantial burden. But of course, as we've already talked about, that's basically just an accounting gimmick. These employers believe that they're still providing coverage for objectionable services. They're still facilitating that coverage. Most importantly, it's very clear that this is not the least restrictive means to achieve whatever government interest is out there. And here's why. It might, in fact, be the most restrictive means, because what you're doing is the government is saying, we think it would be good to increase access to contraceptives. How should we do that? Should we pay for it ourselves? Should we provide it through the Title X clinics and the community health centers that already provide this ubiquitous and inexpensive contraception and abortifacients and sterilization? How should we do it? And what they decided was not to take any of those methods, but instead to take the most restrictive method, which is to say, force religious objectors to provide it themselves, to pay for it themselves, and to facilitate access to it. I think I've seen the briefs. The administration has filed a couple briefs against various lawsuits that are out there. And in no case have I seen a strong argument against the fact that this is not the least restrictive means to accomplish any government interest. Now, the final question is there a compelling government interest here? And I would argue no. Again, the administration would argue that the compelling interest is increasing access to contraceptives, abortifacients, sterilizations. But as I've said before, access to those goods and services is ubiquitous and contraception is inexpensive. And so the question is not just are we increasing access, but to what degree. The Supreme Court has argued that marginal increases in compelling government interest don't amount to compelling interest themselves. And finally, I would note that the real interest going on here is cost shifting. Again, if the administration had an interest in increasing access to contraceptions and abortifacients, they could simply provide it themselves. But instead, what's going on is they're shifting the cost from doing that from themselves to healthcare, to religious employers. And that's the real interest that's going on here. That certainly doesn't amount to a compelling government interest. And legal analysis often looks to analogies, and the great analogy here is to conscientious objectors in wartime. The government can raise taxes to pay for war. Sometimes it's just to engage in war. and you have to pay your taxes to support it. But government does not force conscientious objectors to wage that war for them. And in the same way, here, government should not force religious objectors to provide these services for them. Finally, I'll say that this broad conscience exemption has a great bipartisan tradition in our law. As I've spoken about, the Religious Freedom Restoration Act was a bipartisan attempt to respond to the Employment Division v. Smith decision. It passed the Senate 97-3 and was signed by President Clinton. President Clinton's point man on RFRA, as it's known, Bill Galston, recently said at a religious liberty conference here in town that he thought it was clear that the HHS mandate violated RFRA. Ted Kennedy, at the end of his life, wrote a letter to Pope Benedict saying that he supported broad conscience exemptions. So I will just note that this year, these changes are dramatic changes from the longstanding bipartisan consensus that we've lived with. Finally, where are we today? First of all, you've all heard about the litigation, and I think this was a really proud moment for Catholics when suits across the country, 12 coordinated lawsuits, 43 diverse Catholic institutions stood together to challenge this affront to our religious liberty. And I think it's great that we had large archdioceses, prestigious universities, but also small social service organizations, St. Martin Center in Erie, Pennsylvania, Resurrection Catholic School in Pascagoula, Mississippi, all standing together and saying, we will not let this stand. That coordinated set of lawsuits is out there, as well as a number of other lawsuits. I think today there are some 23 cases, 56 plaintiffs. That's out there, and depending on what happens with the Supreme Court's decision next week, those lawsuits might be our best way to get this decision, this mandate knocked down. You've also probably noticed that universities are dropping their healthcare. Franciscan University of Steubenville and Ave Maria have dropped their student healthcare plans rather than have to worry about complying with this mandate. The Fortenberry-Blunt bill is in the House, and while no action will likely happen on that before November, I think that's an attempt to bring back broad conscience protection, and it should be supported by all of us. And finally, let's talk about that big decision that's coming down next week, the Supreme Court decision on the Affordable Care Act. Everybody asks what's going to happen to this mandate once that comes down, and I think there are three possible things that can happen. Obviously, the court can overturn the Affordable Care Act, and we should all see that as a big victory for religious liberty, because the authority for this mandate comes from the Affordable Care Act. If it's no longer law, the mandate no longer applies. The two other options, without getting too much into the weeds on the legal issues, are that the Affordable Care Act is upheld, or that the individual mandate is struck down, but the rest of the law is upheld. In either of those cases, we'll still go forward with these lawsuits because the authority for the mandate is still there. And so again, the lawsuits will be our best chance to defeat this mandate.